And each time you hear that bed, you know that it is time for us to talk about everything, the laws that has to do. I'm talking about the Acjl, the Administration of Criminal Justice Law 2017. Good afternoon to you. My name is Ifeanyi Awa, and you know this program comes your way every Tuesday from 3:30 p.m. Now, you need to also remember that it is brought to you by the Abia State Administration of Criminal Justice Monitoring Committee and Prisoners Rehabilitation and Welfare Action Power, with the support of the Open Society Initiative for West Africa, OSIWA, and Abia State Justice Reform Team. Previous weeks, we've talked about different angles of the law. We've looked at how it affects us. And don't forget, the aim of this particular program is to make sure that we all get to understand what the law is all about, and it's broken in simple ways that the layman can understand it. Every week, I have legal experts who come here to explain what different sections of this law is. And on this week's edition of the program, I have someone who is going to be explaining something that really affects us. And today we're talking about the institution of proceedings under sections 107 to 109 of the Acjl 2017. My guest this afternoon is Elder Chief Magistrate E. Omar Onwunta, who is a Chief Magistrate Grade 1 and also a magistrate in charge of juvenile matters in Umuahia and environs. I want to say welcome to our studios.
Thank you very much, presenter.
All right.
It's a privilege to be here.
Okay. Now, before we dive into our discussion, we're going to take a very quick break, and when we'll come back, we'll look at what this is all about and every aspect of this law. Stay tuned, and this is Will of Justice. Welcome back, and we're going to dive straight into our topic for today. And just in case you just tuned in, we're talking about the institution of proceedings, that is under sections 107 to 109 of the Acjl 2017. And just like I said earlier, my guest this afternoon is Elder Chief Magistrate E. Omar Onwunta, who is a Chief Magistrate Grade 1 and also the magistrate in charge of juvenile matters in Umuahia and environs. Now, in order to make this easier for us to understand, we're going to start by let's understand what exactly is the institution of proceedings. It sounds like a big grammar, but let's break it down in a way we can all understand it.
You are right, presenter. Institution of proceedings simply means the way and manner a person who has been seen by the public or by any person or by the police as having committed a crime is brought to court. Simple.
Oh. Okay, now that's what the whole grammar is all about. A very simple way. Now we're looking at the angle of how the person is brought to court. And basically this means that you don't just drag someone to court. There has to be proceedings. There has to be steps that have to be followed and how to get this. Now, as the expert here, let's start from this angle. What are the steps that would be followed when it comes to bringing such a person to court?
Okay, before I go straight into how the law puts it in the book,
okay,
the steps practically to be followed is, for instance, when a person is seen to have committed a crime, even you and I can report to the police,
okay,
or report to the court directly. When you report to the police will do their investigations like you know, and then they will bring a charge to the court, to the magistrate court. When I talk of charge now, that's where I'm coming to the Acjl.
Okay.
It's to the magistrate court.
Okay.
Or if they report to the police and it's something the magistrate court is not able to handle because we have our limitations, then the process will continue and an information will be taken to the High Court.
Okay. So that makes it easier for us to understand. Now, according to the books, what has been stated?
Okay, according to the books, what has been stated is that a charge, criminal proceedings can be instituted through a charge or complaint before the magistrate court, okay, whether on oath or not. The thing to be added here is that somebody can just ordinarily walk up to the court and say, I want to make a complaint. People don't know that.
They are just finding out.
Yes, people don't know that. You can get to the court and say, I want to make a complaint. Somebody has done this to me, which is a crime. And then the magistrate will listen to that complaint, whether on oath or not, and then the magistrate can order it to be reduced to writing.
Okay, I'm sorry. The angle of complaining to the court. Let's understand. Over time in the program, we already know you can go to the police and report cases. But when you're reporting to the court, is it more like you bringing up a charge against someone, or is you just walking up to the judge and talking to the judge?
You see, for instance, this mode and manner is rarely used, but I'm just telling you what is in the law.
Okay.
You can walk into a court of justice, the High Court, for instance, the one at Ekmene Road here, and say, I want to make a complaint. Anybody who knows the law should take you to any magistrate or to the registry, and you can state your complaint. The person will now maybe say, come on with me, I'll take you to a magistrate. And you do that before the magistrate will tell the registrar, put this in writing. And the magistrate has the power to inform the police, because you have made that complaint directly to the magistrate.
Okay.
The magistrate can tell the police to look into that complaint and then follow the process as I told you earlier.
Okay, there's something.
That's one aspect.
Okay, that's one aspect.
The other aspect is the most formal way. When people get injured by the acts of others which they consider a crime, they get straight to the police. So the police investigates the matter and prepares a charge. What is a charge? A charge is just a statement of fact that you, so person on so date and at so time, committed an offense by doing this and that, which offense is punishable under the law. And then you're asked to plead guilty or not guilty.
All right. If we spend too much time on this part, we might not have enough time to go through the other angles, because
I agree with you.
This is new knowledge, and it's quite interesting to a lot of us right now.
Can I add something there?
All right, go on.
Some other persons, talking of complaints now, some other persons may have gone to the police and their matters incidented, and they don't think they like the way the police is handling it. The person can now talk to a lawyer who will say, no, I'll make it happen. The lawyer can bring an application before the court, before a magistrate that has power to summon the person and make a complaint. And then the magistrate, having looked at the affidavit, and every affidavit means something said on oath, can now issue a summons to the person. And that means the person is also brought to court.
Okay.
Kind of sidetracting the police ordinarily from bringing the matter to court. But can I tell you one thing? Under this law now, the police don't even have matter to prosecute cases.
Yes.
But we'll come to that, I suppose. Because ordinarily, it's the police that would bring the charge to court. But a section of this law says that every charge or complaint should be signed by persons named in this law. And that section says those persons should be Attorney General or the officer of his department, that is to say the lawyers working under him, or what we call ordinarily fiat, a legal practitioner, private legal practitioner, whom the Attorney General has given the power to prosecute that charge, or any other legal practitioner authorized by any law to prefer the charge.
This is one of the changes brought about by the Acjl.
Exactly.
And over weeks, we've got to hear from different persons talk about this particular part of the law. But let's go over to section 108. And please permit me to read the A of it. States, one states, criminal proceedings instituted in a magistrate court may be A, by bringing a suspect arrested without a warrant before the court on a charge contained in a charge sheet, specifying the name, address, age, sex, and occupation of the suspect charged. Is alleged to have been charged. The charge against him at the time and place where the offense is alleged to have been committed, and the charge sheet shall be signed by any of the persons mentioned in section 104 of this law. Now, basically, this is saying things to be contained in the sheet, right? But because of not going through 104, it says by any persons mentioned in section 104 of this law. So, just for clarity's sake, what does that part mean, the 104? Who are those persons who can be signed?
Exactly what I told you a moment ago. Section 104 says that the persons that will prosecute offenses in any court are the Attorney General or any officer in his department, a legal practitioner authorized by the Attorney General.
Okay.
In practice, we call it a fiat. If perhaps you have a lawyer, you don't like the government lawyer that is handling the matter, you can engage yourself, a lawyer,
Okay.
and the lawyer will seek an application from the Honorable, the Attorney General, who will give him fiat. Fiat means consent to go ahead. That's another person that can sign it then, or a legal practitioner authorized to prosecute by this law. This law still meaning the Acjl or any other law. For instance, like now we are in the circumstances of a COVID-19, they may be set up a COVID-19 team and then a lawyer assigned to them to prosecute offenders under the law.
Okay.
But the important thing to note that here that is that the police are no longer the prosecutors in the magistrate court by this law.
All right. Now, let's go over to B. Because of time, I'm trying to speed up things so we can cover all of these sections. It says so that B of 108, that is, says, subject to the provision of section 89 of this law, by complaint to the court, whether or not on oath, that an offense has been committed by a suspect whose presence the magistrate has power to compel an application on the magistrate in the manner set out in this section for the issue of either a summons directed to or a warrant to arrest the suspect. I think this is what you explained earlier too.
Exactly.
So you can complain straight up to the magistrate who gives summon to the person or a warrant of arrest.
Yes.
Okay. Now I think we already
I already summarized it.
Yeah. Now
and there's something to note.
Okay.
By that section 89, when you make complaints like this to the magistrate, so that the magistrate does not become the court and the prosecutor and everything, the magistrate will also direct the complaints to the police, because there needs to be proper investigation. Otherwise, most people can abuse this kind of...
Yes, they can.
Yes.
They can. Now, let's go to 108. That is section 2, where it states the charge sheet filed by the prosecution shall be served on the defendant within 7 days of its being filed, or such time as the court may allow. I think this is self-explanatory. And the 3 says the trial of a charge preferred under subsection 1A of this section shall commence not later than 30 days from the date of filing the charge, and the trial of the person brought under the charge shall be completed within a reasonable time. So this angle also talks about the aim of the Acjl, which is speedy dispensation of justice. Now, let's move ahead.
But there's something you need to know about this provision. It's good. It's a good provision.
Okay.
But what's may be considered reasonable time is a question of circumstances. Unlike in the more civilized countries where technology is there in aid of the judges or the magistrate, here you need to know that most magistrates, well, not most, all the magistrates still write longhand. And things like sharing of courts, because like now we have lots of magistrates in Abia State and we still share courts. So you don't have that ample the whole time to dwell on one matter, because you want to finish it up within a reasonable time. And then there is also the lawyers. Like today there are cases that came before me and the lawyers say, I'm sick, I want an adjournment. So no matter how much you want to speed it up, there are circumstances that are limiting us in this part of the world. Now, for instance, the COVID-19 that just happened.
Quite
Most
understandable,
cases,
yeah.
yes.
So means at a reasonable time can even go up to a year end.
Well, under the law, the reasonable time perceived by the law is 180 days. I think that's 6 months. But I tell you that in practice, most of these matters don't end within 6 months.
Okay.
Yes, for the circumstances I have just explained to you.
Now, let's go to 5.
Okay.
It says a court seized of criminal proceedings shall make quarterly returns of the particulars of all cases, including charges, remand, and other proceedings commenced and dealt with in his court within the quarter to the chief judge. Now, could you explain that part? Let's have a better understanding of it.
Very simple. Just as we sit as magistrates, you're supposed to make quarterly returns of all the criminal cases that are before you, whether you finish them or the ones you struck out or dismissed, or the ones that you didn't have power to entertain. By that I mean the magistrate court is the court of first instance. So everybody that commits an offense, even armed robbery, is first brought to the magistrate court. But magistrates do not have jurisdiction to try that because of the law creating them. So what you do is to use the process of the law. It's also in this Acjl, and then it lands the offender, well, the defendant, because you can't call him offender at this stage, the defendant in correctional services. That is what people call, in layman's language, awaiting trial. So the person is there. But what is important to notice here is that at the end of every quarter, you write out the number of cases that came to you that quarter, even those carried over. You write out in a column the numbers you disposed of through judgment. That is, you fully heard and determined. You write out the ones you, for instance, dismissed. Sometimes people settle while the matter is in court. If it's not such a serious offense, the court, for the interest of the society and for peaceable, existence in the society, we allow them to settle out of court and they report back to us. You still feel it in that column as disposed and manner of disposition, and then you write out the ones that are still ongoing. This will enable the chief judge to evaluate how fast cases are going, and he can make inquiries to know what slowed down any of the processes. You understand what I mean? Yes.
Now, based on what you're saying, all this is still aimed at making sure that a speedy dispensation of justice.
Right.
And 6 does talk about this angle where, in reviewing the returns made by a court under subsections 4 and 5 of this section, the chief judge shall have regard to the need to ensure that criminal matters are speedily dealt with. That is A. B. Congestion of cases in courts is drastically reduced. On that, C is congestion of prisons is reduced to the barest minimum, and persons awaiting trial are, as far as possible, not detained in prison custody for a length of time beyond that prescribed in section 293. With all this being said here, there are still challenges to this, just like you said earlier.
Very many challenges.
Because there are always things that drag these cases on. And we will talk about the angle of the congestion of cases in courts being drastically reduced. How easy is it?
It's not easy at all, for the reasons I had given you early. The magistrate or the judge may be well composed to go on with a matter. For instance, sometimes the defendant is not produced, and they will give a reason, and the law says if you think the reason is reason enough, you allow an adjournment. Because too much hurry, of course, can also lead to denial of justice. For instance, if they tell you that a defendant is sick and hospitalized, and they bring a letter to that effect, you cannot go on. Or that the person that is supposed to be a witness just got knocked down by a car and has been rushed to the hospital, you cannot go on in that case. Or the lawyer, which is sometimes the case of the defendant, the defendant is what people call the accused, but we now call them by this law defendant. The lawyer says, I am sick, and he writes a letter. I am not able to be in court. The law says, in the interest of justice, you let that defendant who is entitled to a lawyer take an adjournment. Because sometimes if you say the defendant must go on, he may not be armed with the relevant knowledge to go on with the matter all by himself. So some of the things, these are some of the things that makes it difficult to go on at the high speed that we may desire.
Now, before we go on a break, let's look at 7. It says the Administration of Criminal Justice Monitoring Committee shall have power to consider all returns made to the Chief Judge under subsection 4 and 5. Now, I do not want to go through this because of the length of it. Now, just explain what this part is saying.
It means, there is a committee known as the Administration of Criminal Justice Committee. They have been set up by the power of this law, by the Chief Judge. And the whole aim is to have persons that are monitoring what is happening. I think they are one of the stakeholders of this program.
Yes, they are.
Yes. And so what this section is simply saying is that when you make these returns to the Chief Judge, they can go and collect the returns from the Chief Judge and look at the columns and know what needs to be done. For instance, they can go to the returns and find out that the number of persons awaiting trial is so very much. I suppose they can now make, demand or plead with the chief judge to do what we call goal delivery. The chief judge can go into the correctional services center and look at people whose offenses are so minor that if you keep waiting for the court to hear them, you could wait for a longer time to come. The chief judge can also look at people who have stayed so much time, more than the time they could even have stayed.
Yeah.
Have they been convicted of that offense? And he can do something. He can even summarily hear it there and decide it one way or the other.
Okay. If you're just tuning in, this is Wheel of Justice, and I've been speaking with Elder Chief Magistrate E. Omar Onwunta, who has been explaining the institution of proceedings under sections 107 to 109. Now, we've looked at 107 and 108. We want to take a very quick breather. When we come back, we'll look at the last section, which is 109. She gets to explain it for us. Then we'll round off today's edition of We Love Justice. This is still Wheel of Justice, and don't forget, it's brought to you by the Abia State Administration of Criminal Justice Monitoring Committee and Prisoners Rehabilitation and Welfare Action Prawa, with the support of the Open Society Initiative for West Africa, OSIWA, and the Abia State Justice Reform Team. My name is Ifeanyi Awa, and we've got a few more minutes left on the program, and I have Elder Chief Magistrate E. Omar Onwunta. She is the chief magistrate grade 1 and also the magistrate in charge of juvenile matters in Omaya and environs. We'll be looking at the institution of proceedings, and she's explained every part of this. Now we're going to look at the last section of this before we round off, and that is 109. Now, because of time, just to summarize 109, what does it actually say?
The summary of 109 is an obligation on the comptroller of the Correctional Services Center. I think we don't call them prisons again. To make returns every 90 days to the chief judge of all persons, of all inmates in the Correctional Services Center that are awaiting trial. You remember I explained what awaiting trial means. Yeah. Awaiting trial, and who have stayed more than 180 days in that center. The aim of this is to acquaint the chief judge of what is really happening in practice, so that the chief judge can look through the list again and perhaps find out persons he can, pardon, or persons whose matters he can try during goal delivery. For instance, if there are persons of this nature and they are very old and maybe seriously sick, the chief judge can try or can order the court, the appropriate court, or the attorney general to do fast and file an information before the appropriate court.
Okay.
And then, of course, you know that when these returns are made by the comptroller general, they also sent to the attorney general of the state, so that they can work hand in hand, so that when the chief judge goes for goal delivery, normally the officers of the Department of the Attorney General also go with him, and most honorable judges go with him, as well as learned magistrates, so that orders can be dished out there on the spot by the chief judge concerning what can make the matters go more speedily.
It sounds very beautiful when you hear this part of it. My question is this actually been done?
Yes. Well, it's been... The answer is practically yes. Okay. Whether it is being done now every 180 days is a question I think you can direct to the Comptroller General. But from my own understanding and from what I have seen, it's been done. Because late last year, late last year, the chief judge brought inmates from the Correctional Services Center, and he was hearing their matters quickly, and then making sure they leave that place for fear of attack of COVID-19 pandemic. Yes, it's been done. I should say so.
All right, thank you very much for coming and thank you very much for explaining these sections to us. And please don't forget that the idea of the program is to break this down in ways we can all understand it, so you get to know what your rights are and you don't get to fall for the wrong persons. And yet again, I want to say thank you very much, Elder Chief Magistrate E. Umar. I want to thank you very much for coming through this today. I'm hoping you can come again some other time.
Yes, of course, always. It's my privilege.
All right, thank you very much. Please don't forget this program comes your way 3:30 every Tuesday. It is brought to you by the Acjl State Administration of Criminal Justice Monitoring Committee and Prisoners Rehabilitation and Welfare Action Power, with the support of the Open Society Initiative for West Africa, OSIWA, and Acjl State Justice Reform Team. My name remains Ifeanyi Awa. Till next week, please keep staying safe. Come